Congressman Adam Schiff is a ranking member of that committee, the House Permanent Select Committee on Intelligence. And let me begin with this. I do not really understand what happened today. So if you could just explain, I mean, Bannon was called before the committee, and what happened when he got there in the beginning?
Yes, he was brought before the committee on a voluntary basis, but he quickly informed through his counsel the committee that he was not going to answer questions that pertain to meetings, conversations, events, etc., that took place either during the transition or while he was part of the administration. And what's more, we would later learn, that would be extended to even after he left the White House concerning conversations that he may have had with the president. This was characterized as a result of his being there voluntarily. He's there of his own volition and therefore could refuse to answer questions based on what the White House instructed him to do. We then were able to promptly provide him with a subpoena, and they went back to the White House and got the same instruction back again. Basically, we don't care whether it's under compulsory process or voluntary basis. We're instructing you effectively putting in place a gag rule saying you can't talk about what happened while you were in the transition team or part of the transition or in the White House. Now, there is no privilege that broad, obviously, and the way they were instructed not to answer questions included not only questions among people within the administration or among people within the transition, but even when he talked to people outside of the administration. So apparently, he was able to talk to people outside the administration and not be gagged, but when it comes to telling Congress about those conversations, the White House wanted him to refuse, and he did.
But I'm confused, because is this a formal invocation of executive privilege by the White House?
No, I mean, this is the broadest effort to effectively gag a witness that we have seen. In the past, we've had a witness that might refuse to answer a question about a specific conversation with the president and claim, well, we want to preserve the White House's ability to invoke a privilege down the road. Now, we don't recognize that either, but we have not been able to prevail upon the majority to follow up by subpoenaing these people, and when they were subpoenaed, insisting on an answer. Here was a very situation. It wasn't merely a conversation with the president that they sought to preserve some later claim of privilege, but rather any conversation that took place during the time on the transition, and any conversation, meeting, whatever. We couldn't even ask about, were you present at this meeting, without getting on the advice of the White House, I'm not going to answer. So it was as broad a claim as you could make, not founded on a particular privilege, but founded on the, we'd rather you don't answer those questions because maybe later we'd want to exert some privilege over something.
Let me make sure that I'm tracking this. He comes in, he says under the advice of the direction of the White House, he's not going to answer questions in this huge portfolio of issues. The majority, the chairman then issues a subpoena. He goes back to the White House. They say this, we're still directing him the same way. He's there for 9.5 hours. Was it just the committee asking him questions and him then not answering based on that invocation of this incredibly broad sense of a privilege?
Well, actually, we asked him whatever series of questions that we had that predated his time on the transition team and in the administration. So we were able to ask him about things that happened during the campaign. But then a lot of this was taken up as we would recess so that they could seek further advice of the White House. But also was establishing the record. We needed to ask him specific questions, have him decline to answer them on the record since he was now under compulsory process, because the way that we can compel that now is having a record that, if necessary, we can take to court.
Do you think, did you know already about the grand jury subpoena of Mr. Bannon prior to the news breaking today?
The first we learned of a potential subpoena before the special counsel or the grand jury was when a news clipping was brought into the committee room. So no, if those reports are accurate, that's something that I only learned about in the press report.
And whatever rules he gave to you presumably would not extend to the special counsel, right? Or, I mean, can he just do the same thing in front of Mueller's investigators?
My view is no, that this is a essential global gag rule when it comes to anything during the transition, anything during the White House, and a lot that happened after the White House. That's never going to fly with a special counsel. It shouldn't fly with us. I don't think it's going to fly with us. We have asked him to return to the committee in short order. But no, I don't think that's going to work with special counsel. I don't think the privilege is that broad or anything like it. And I don't think that he can, the White House can use that to shield him from our questions either.
I just want to be clear here. Your committee has talked to a lot of witnesses. You have been slogging through a lot of internal tension back and forth. What happened today has never happened before. Am I correct?
No, that's absolutely true. And, you know, and I don't know that I can account for the reason why the majority is handling this situation as so much differently than in the past, because we have had other witnesses refuse to answer a much narrower category of questions, but still we have sought subpoenas from the majority and they've been unwilling. When the witnesses were subpoenaed and they refused to answer questions, we've sought to use compulsory process and they've been unwilling. So this was very different in kind. I'm not sure I can explain why, but I do applaud it. I think this is the way a committee ought to undertake to get answers from reluctant witnesses or a reluctant White House.
So final question, you're going to have him come back, right?
Yes.
And you, I mean, then what?
Well, I imagine this is the way it's going to go. They're going to go back to the White House. They're going to now say, look, we were subpoenaed to come in. On your advice, we declined to answer all these questions. Now, I'm going to speculate here about what Bannon's attorney is going to say, but I think counsel is going to understand that's not sustainable. I think the White House is going to understand that. So my guess is that they're going to try to come back and narrow their refusal to cooperate to a more limited set of questions. But frankly, unless they invoke privilege, which they have not done, there is no basis for this witness or any other to refuse to answer our questions. So the next step after that is if the White House takes an unreasonable position or the witness refuses to answer, we would have to go to court to